Thank you very much, and good afternoon. Good afternoon to our viewers. Good afternoon to our panelists. Thank you for giving the time that is greatly appreciated. This is the first of 3 episodes for advanced bankruptcy transactions. This episode is entitled Representing Asset Purchasers in Bankruptcy. My name is Cliff Katz. Again, I am your moderator. I'm a partner with the firm of Getz Platzer LLP. I'm excited to introduce our panelists, a very experienced and knowledgeable group, starting with James Sullivan from Seyfarth Shaw LLP. Thanks, James. Richard Corby, a member and founder of the law offices of Richard J. Corby PLLC. And Jonathan Friedland, a member of Much Shellest PC. Again, thank you very much. Their bios can be found in the About the Faculty page in this PowerPoint. As I noted at the opening, this webinar is part 1 of the Financial Poise webinar series, Bankruptcy Transactions, Advice for the Advanced Practitioner. Speaking of slides, you should understand that we will not run through the PowerPoint in a 1, 2, 3 order, and we'll be jumping around. Nor will you have to listen to us read any slides. This webinar is intended to be in the form of a conversation. Keep the PowerPoint handy, however, because I will try to indicate what slides our conversation is touching as we proceed, so you can take notes. Now let's just continue. The webinar is a production of Financial Poise. To sign up for Financial Poise free weekly newsletter, go to www.financialpoise.com or shoot an email to info@financialpoise.com with the word subscribe in the subject line. If you are attending the live premiere of this webinar, congratulations. You can submit questions live through our web portal. If you are watching this on demand or have questions after the webinar, you can send an email to info@financialpoise.com. Just include your question in the name of the webinar episode, and we will do our best to send you an answer. Finally, a word about our sponsors. Today's webinar is sponsored by Max Asset, an online auction provider, and the Daily DAC. So let's start our show. We're starting off actually in reference PowerPoint pages 11 through 14 for those of us who are following along, general background and bankruptcy sales. I'm going to ultimately turn this over to James. James, let's talk about the basics. Section 363 of the Bankruptcy Code. Talk to me. What's this all about?
So if a debtor wants to sell an asset outside the ordinary course of business, it needs to follow the procedures laid out in Section 363 of the Bankruptcy Code. Now, what does it mean to be outside the ordinary course? It depends. It depends on the debtor and the nature of its business. For example, typically speaking, if a debtor wants to sell real estate, that would normally be a sale outside the ordinary course of business, and they would need court approval for that. However, if a company was in the business of buying and selling real estate, that's what its business was, and it sold real estate in the ordinary course, then that probably would not require court approval unless it was potentially a very, very large piece of real estate, given the scope of the debtor's assets and liabilities. So it's a very fact-sensitive kind of analysis. So, and the benefit of a Section 363 sale is it allows for a fairly expedited sale process prior to the approval of a Chapter 11 plan. And the sale is free and clear of all claims, liens, and encumbrances. And it's on notice to all creditors. Parties have an opportunity to weigh in and object, and ultimately it requires court approval.
Great. Thanks, James. So John, just turning to you, what is typical, in some cases unique to a bankruptcy sale? You know, talk to me about free and clear. Is it always free and clear? What's going on here?
So you want me to compare a sale inside of bankruptcy to a sale outside of a bankruptcy?
Yeah,
and what's different. So the free and clear notion is different. If I'm buying your company, if I'm buying all of the assets, I can disclaim in the purchase agreement outside of bankruptcy. I can disclaim liabilities, but that disclaimer may or may not hold water. If I buy your stock, I certainly can't exclude liabilities. But inside of bankruptcy, if I get a free and clear sale order, then I know that the corpus of assets I'm acquiring is in fact um, free of any of that stuff, liens, claims, and encumbrances. Um, and so that's sort of maybe first and foremost. Um, Bankruptcy sales by their very nature have a large element of being public and transparent. If I want to buy your business outside of bankruptcy, we don't need to open that up to the world to see. But there's a saying that all bankruptcy professionals are well aware of. Bankruptcy is a fishbowl because people can see what's going on, and um, the sale of assets by a debtor in bankruptcy or a trustee is quite transparent to anybody who wants to see. Most sales, particularly of there's always an element of higher and bidding. Some sales, there's a process, and if you're talking about larger asset sales, it's almost always subject to higher and better bidders coming in. The sales are noticed up to the public so that people can see and maybe decide to bid. In small little cases, Chapter 7 trustee is selling a car. Technically, it's open to higher and better bids, but there's not much of an auction process because there's a blue book and the trustee usually can just sell it as long as, again, notice is given. So should someone want to come in, they could to try to overbid. Um, so the whole concept of the auction, staying on your question, what's different? The whole concept of the fact that if I want to buy your business, you don't need to hold it outside of bankruptcy. You don't need to hold an auction. You can take less than full value. If I want to offer you $1.5 million, even though you can get $2.5 million, generally speaking, you can take it. You don't need to have an auction. Inside of bankruptcy, that's completely not the case. Those are a few differences.
Okay, well, John, just following up on that question, I mean, what factors may push you one way or the other to have a bankruptcy sale in a bankruptcy courtroom versus doing it or trying to do it outside of a courtroom?
Well, are you talking about the question of whether to file bankruptcy in the first place?
No, well, I guess the answer is when you're in a bankruptcy, there's no question that you need to do it. But why not, if the case is no longer going to reorganize in a traditional reorganizing role where the company comes out and restructures its debt, and this becomes a case where there's a sale case, what factors would you look at to say, okay, let's have this sale in the bankruptcy versus dismissing the case and having
Oh,
outside the bankruptcy?
that's a totally different question. If a case is dismissed, um, then and you that puts the debtor back in control. And so one clear factor is, and by the way, whose perspective are you asking from? The buyer's perspective,
Well,
or so
What,
from
why
the
don't we, the
buyer's?
answer is let's try and throw it out to the group, and I'll throw it out to the group after. Give me what the buyer's perspective would be.
Well, the buyer's perspective is it's once the bankruptcy is filed, the a buyer is typically going to want it to be sold in the bankruptcy so that the buyer knows that it can get the free and clear order. There's no such thing outside of bankruptcy. Now, if you go back in time to, distressed company talking to potential buyer, um, and it's pretty common for potential buyer, and that's probably the more common scenario for the question to arise. So I'm talking to you about buying your company, and your company is hanging on by a thread. It's financially distressed. Do I want to buy your company, whether it's assets or equity, wouldn't buy equity. That's just, I'm throwing that out to be complete. It would be an asset deal. Um, because I wouldn't want the liabilities to come with equity. But do I want to do I say to you, I'll buy your company, but I only want to buy it in bankruptcy because I need that free and clear order? That's the pro. And the con is I'm not going to I'm going to have to, I know it'll be subject to higher and better bids because in bankruptcy, that's what's going to happen. And so that's sort of that's the question that usually, has to get answered. Now, of course, bankruptcy isn't the only option to try to get um, some level of free and clear. If you can buy at an Article 9 sale, you can at least buy free and clear of liens. Maybe not claims, but liens. So anyway,
Okay,
it's a
well,
multi-level analysis.
so a couple things. One, Rich, let me turn to you. Where, by the way, we're still focusing on slide 13. And John talked about some of the reasons why a buyer might look at this. Are there limitations and risks that a buyer should be concerned about in purchasing as a 363?
Sure, if they want it, if a buyer, for instance, I know we'll get into this, whether it's a strategic buyer or a financial buyer. If it's a financial buyer, which is usually an investment firm, hedge fund, private equity firm, a lot of those firms uh, have proprietary information about their investment strategy and may not want it public. And as John said earlier, bankruptcy is a fishbowl. And if you're putting in a bid to buy an asset, you have to abide by the bankruptcy court rules and participate in that fishbowl, which means other parties in the bankruptcy case could due diligence on that financial buyer. For instance, whether they have the ability to close, do they have the funds to do it? Is this the type of business that can succeed and will actually be the best possible sale? And then some of the other risks are the buyer could be outbid at an auction, but there's one way to get around that, and we haven't really touched upon it, is that they could propose that the debtor do a private sale in bankruptcy, and that's not really in the statute of Section 363. It's in the rule of 6004, the Federal Rules of Bankruptcy Procedure, that you can conduct a private auction, a private sale in bankruptcy, whether it's the assets or the stock of another company, if you can generally prove, if the debtor can prove that they've done all their marketing they could, there's no real market for this type of asset, then the buyer could still get the benefit of the free and clear of liens, claims, and encumbrances of the sale without having to go through the auction. It's important to note that there's nothing in the statute that requires the debtor to hold an auction. It's just more good practice that the debtor conduct an auction so that the market speaks. And if there's a dispute about, and I know we'll get into those later, a dispute about valuation or the value of the bid, that usually the market dictates it. To get to John's example, and I know I keep going back to John like I forgot James, but I haven't. To get to John's example about the car, there's the Kelly Blue Book value in the car. That's what it is. There's not going to be someone competing for that. Oh, I can offer higher and better. But generally, those are, if you want the benefits of bankruptcy, you have to take the risks. And as a buyer, and this is what I always advise clients, and is that you generally want everything blessed by the bankruptcy court, because if there's a jilted bidder or a creditor looking to have holdup value to block the sale to ensure that their claim gets paid in full, most bankruptcy cases, parties don't get paid in full, creditors don't get 100 cents on the dollar. You can point to a factual record that that the court creates, that the debtor, you know, it was the best, it was a sound exercise of the debtor's business judgment, um, and therefore the sale should go forward.
So let me ask you, Rich, just as a follow-up, uh, if I'm a buyer, am I worried about successor liability like I potentially would be outside of a bankruptcy?
Generally, no, because that's exactly one of the issues of why a buyer would want this subject to a bankruptcy court approval. They would want a finding by the court that the buyer is not a continuation, that new co is not a continuation of old co. Whether that's to address, employee claims, environmental claims. The only time a buyer runs the risk of being deemed a successor of the old co is if there really is no change. And when I'm speaking at 30,000 feet here because that's such a fact-intensive inquiry. And normally, if a sale wouldn't go through in bankruptcy, if a buyer didn't have that protection or finding a fact and a conclusion of law from the.
So let me throw this out to the group. Would that, in hearing what Rich had to say, would that change anyone's view if the buyer was an insider on successor liability?
I think it's going to be scrutinized a lot more, right? And judges are going to scrutinize it much more so. And look, there's definitely some cases. The cases are a little bit back and forth on it. I definitely think if I'm worried about successor liability, I would much rather be in bankruptcy court and try to get the judge to make a finding or a ruling that the sale is free and clear of all successor liability. But oftentimes you'll have to go through certain extra steps and procedures. For example, you may need to get like a few claim, if it's like claims you're worried about, you may want to get a futures representative to be appointed to look out for the interest of potential claimants whose claims have not yet been realized, or they may not realize that they have a claim, if it's because of some design defect that hasn't materialized yet. But again, it's not going to be foolproof, but I think you're much better being in bankruptcy if you're worried about successor liability types of issues.
Okay, so James, let's stay with you for a minute. How does a distressed company come to put itself and some of its assets up for sale? And as a compound question, where does the pressure come from to make that decision?
Oftentimes, a debtor is pushed into it from external forces. Typically speaking, at least initially, it's because the debtor has financial constraints. It has creditors coming after it, oftentimes secured creditor or lender. And usually it's a compromise. Instead of having the lender foreclose on the assets, they may encourage a bankruptcy, provide some financing in order to allow a sale process in bankruptcy. The other place where it might come from is if the debtor is looking to sell the business and the buyer is the one that sort of suggests the bankruptcy. It may say, like Jonathan said earlier, look, I'm really interested in these assets. I want to buy it, but there's some things in your business I'm worried about. Successor liability could be one of them. And I would really rather do this sale in a bankruptcy. So why don't you file for bankruptcy and we'll do a sale process, and we'll do it that way. So those are usually the parties that I see that influence the decision to sell the assets in bankruptcy. And then whether or not you do it under Section 363 or a plan process is usually contingent upon the timing of it, right? You may want to do it a little bit quicker if you're worried about reputational reasons, you're worried about your employees getting poached by competitors, you worry about like the value of the assets of the company dropping precipitously. So in that situation, you're likely to try to do a sale, fairly quick sale process. Usually, these sales happen fairly quickly in the first, 60, 90 days of a case. If you have some time and you want to do some restructuring initiatives first, then you may decide you want to sell the assets under a Chapter 11 plan. And, if you do it under a plan, there's some certain benefits of doing it that way as well. But so those are the main factors that are often influence the decision whether or not to sell the company in a bankruptcy.
Just staying on that for 1 minute with you, James. How does a debtor or even a committee or a lender determine if there's a market?
Typically speaking, I would say in most cases it's been shopped to some extent prior to the bankruptcy filing, not always. And sometimes they'll even have a lender, they'll find a lender beforehand. That's called a stalking horse, right? So they'll have the stalking horse agreement signed up with a buyer before the bankruptcy. and it will be contingent upon, the bankruptcy being filed, if it's signed up before the bankruptcy, and the sale process run after the bankruptcy. Or sometimes you'll see it after the bankruptcy is filed. Sometimes the debtor doesn't have the luxury of completing its marketing before the bankruptcy, and it'll do it afterwards, or maybe like some of it before, some of it after. So a lot of it depends upon some of these external constraints that are being placed on the debtor. How much money does it have? Is its lender being cooperative, et cetera?
Okay. Rich, turning to you for a minute, I'm going to ask you to put on your investment banker hat. Talk to me about the types of purchasers that we normally see coming out of these 363 to buy assets.
Sure, there's usually two types. There's a strategic buyer, which is usually a competitor or another company in the same industry as the debtor, or a financial buyer, which is an investment firm, private equity firm, a hedge fund, or it could be a group of sophisticated high net worth individuals looking to purchase an asset. The strategic buyer may be what they're looking at is how does this asset increase the value of their current company? For instance, if it's a retailer or if it's a food manufacturer, does, does the debtor have, for instance, I've seen this before where do they have certain routes in certain parts of the country that the buyer is not in, and they could use this opportunity to buy that debtor entity to get into a certain market, and as opposed to a financial buyer, they're looking at more of it as an investment. How does it increase the total value of their portfolio as a larger investment firm? For instance, if this was many moons ago, the newspaper cases, there was one fund that went and bought up a bunch of the newspapers as part of a larger roll-up, similar to some funds only focus on manufacturing and maybe purchasing an asset out of a manufacturing company out of bankruptcy and having add-ons to that, and sort of a separate roll-up strategy. So really, the strategic buyer is focused on the here and now with just one particular business, whereas the financial buyer is, okay, how can I maybe add this on to other investments that it already has, or maybe wants to break into an industry, and somehow the bankruptcy is sort of the best way to um, show off their deal sheet when they approach other buyers. I have a client where we were in a deal and they won the auction, they won the asset, and they were able to use it to showcase to other potential buyers, both in court and out of court, that, hey, we do this a lot, so you should consider us.
Okay. So actually staying on that for one quick second as a follow-up, can you explain to me what the difference is between buying under a 363 as a going concern versus buying specific assets? What are we talking about here?
So a going concern is essentially what it is. You want to continue the asset going forward. The company will continue, but it'll just be a new entity, a new co with new management, most likely. Uh, the only thing that usually stays is that the new co usually hires the old employees back to the new co. Again, this to touch base on that successor liability issue. Uh, the going concern is that, it's not liquidating. Now, if you're you know, just buying part of the assets, it may be a straight up liquidation. It could be a plant. It could be, you may want a company just for their customer lists or their IP, and the buyer would restart the IP under a different company. You see that in a lot of the retailers. I know in New York, the Fortunoff company went into bankruptcy twice, but it was a retailer with pretty much liquidated the second time around, but that name still had value, and I still see some of the sharper image, intellectual property around. And there's also one investment firm that buys a lot of the old retailers that sort of rebrands them and restarts them going forward.
General question to the group. Is there a concern, or should there be a concern as a lawyer for one of the constituencies, that the assets are going to be cherry picked in some degree? And what does that mean, if you know?
Well, I think
Well, I
cherry
think
picking sometimes is okay, right? A lot of it depends upon the case, right? So, and that's one of the wonderful tools that bankruptcy offers, right? It offers, it's not a one size fits all. Some cases, you'll have buyers that will go in and pick the most attractive assets, and then the rest may get, maybe liquidated or sold at a fire sale. But you may be able to aggregate buyers, right? To, maybe you'll find, one buyer is not going to be interested in all the assets, right? So you'll try to get different buyers to buy certain assets and try to compete with buyers interested in buying all the assets. That happens now and again. So.
Anyone else have any views? I'll throw that
Well,
open.
yeah, if you take a step back, your question kind of implicates the business judgment rule, and it implicates whether we've got a debtor in possession who's acting appropriately. A debtor in possession, the company that filed, is given the benefit of the doubt to begin with. Unlike in other countries, in their insolvency regimes, the people running the company that drove it into bankruptcy, taking like a cynical view, good companies and good people sometimes find themselves in bankruptcy. But there's a arguable irony that the same management and board that created the situation that caused the company to be in bankruptcy get to run the company in the bankruptcy. There's no automatic appointment of a third party trustee, unlike in lots of other legal regimes throughout the world. So the debtor is the debtor and the debtor in possession. That phrase, that term, signifies what I just described: the fact that they remain in control.
isn't
Um,
that though where the committee, a committee could come in and sort of act as a second board of directors?
well, I would argue you raise a good point. I wouldn't call it a second board of directors, but you raise a good point. There are so the default, the presumption that the debtor deserves to stay in possession can be overcome if the debtor's doing bad things. And the structure, the existence of a committee in uh, most Chapter 11 cases of any size, you're right, that's a counterbalancing force, just like a secured lender. The committee has a voice at the table. A committee can object to anything, that's going on. Secured lender that has a lien on all of the assets of a debtor is well motivated to protect its interests by doing the same thing. But and if let me take us back to the question. I'm getting far afield.
Yes.
If the question is about cherry picking, and so if I've got a DeLorean time machine and someone just wants to buy the flux capacitor, and without the flux capacitor, the rest of the machine is worthless, then I'd say in that hypothetical, if I'm the debtor, I'm trying to sell the flux capacitor, I'm gonna that my motion to sell is gonna engender a lot of objections. But if, I've got 19 factories and I want to sell one of them, and it happens to be, maybe the best factory, there may be all sorts of good business reasons to sell that one. There's nothing, as one of the other guys expressed,
Right.
the term cherry picking is not inherently a bad term. It can be, but it's not inherently.
Okay. So actually, let's stay on that topic,
Doesn't
John,
that
a
tell you the
little bit.
value of the assets if you have cherry picking versus all of it? Because you get to, I know we'll get into this later, but the value of the bids.
Oh, that's true. That's very true. But so let's turn to one other, I guess, constituent potentially, and that is the foreign buyer, John. If I represent a foreign buyer coming into this market using the U.S. bankruptcy laws, having no familiarity potentially with this whatsoever, you know, what are the implications of me buying it? And how welcome will I be in your courtroom?
Am I a judge? Um,
Well, you're the ultimate determination of whether or not this buyer is equally competent versus another buyer. But let's just talk about
sure.
what some considerations that a foreign buyer may want to look at in coming into this market, if there are any.
Yeah, well, first of all, if as an attorney, if I'm representing whether it's a debtor or a buyer, it could be a very sophisticated, let's talk about buyers. Lots of private equity funds will sometimes come in and be buyers in bankruptcy proceedings, and they may be extremely sophisticated deal people, but if they've never done a distress deal in bankruptcy, there's a learning curve. And it can be a significant learning curve. So add on top of that, if we're talking about a foreign buyer, I pronounced that funny, foreign buyer, um, there's even more of a learning curve. Now, legally, there are things that come up in the context of a foreign buyer that simply don't exist if we're talking about a domestic buyer. The most obvious may be the CFIUS rules, what's it called? The Committee on Foreign Investment in the United States has, there's rules, national security concerns could trigger a CFIUS review. If you're dealing with anything that has like a military application, probably, AI, telecom, technology type stuff, or anything that's, a government contractor. So that's an example of something that exists with respect to a foreign buyer that just doesn't in this if it's just a domestic buyer. Um, the Treasury Department, I think we still have a Treasury Department, has an office of foreign assets. What is it called? The OFAC, Office of Foreign Asset Control, that prohibits transactions involving sanctioned countries. So if you get a call from an Iranian or a North Korean company that wants to be a buyer, you may want to listen, if they want to wire your retainer, that's one thing, but you probably want to advise them they're probably going to have a problem actually doing a deal. Um, there's all the normal stuff that still applies. There's Hart-Scott. If we're talking about a foreign buyer, um, I'm certainly generalizing, but it's more likely than not, we're talking about a transaction that's a larger transaction. It's a larger company. The last time I checked, you don't have companies from Italy coming in to buy a one location pizza shop in New York City, You're probably talking about more significant assets. So you're going to have things like, Hart-Scott-Rodino apply, which is the, thing it's a antitrust element, right? To prevent too much concentration in a market. That's absolutely applicable if the transaction is large enough, whether or not it's involving a foreign player. It's just that all else being equal, it's more likely to be large if it's attracting a foreign buyer. Not from the buyer's perspective, but from everybody else's perspective. If your buyer is out of town, so to speak, out of the country, um, what what baseball bat does the court have to enforce? What if the buyer breaks its agreement? As a practical matter, how are you going to go after the would-be buyer if the buyer breaches? So, an example of an obvious protection is maybe if the foreign buyer wants to be the stalking horse and you normally require whatever, 10% deposit, parties in interest may make a persuasive case to get a much larger deposit, that kind of thing. I'll shut up. I'm talking a lot.
No, no, I'm actually you transitioned very nicely into really the next area
Well,
of
thank
discussion,
you.
which is really about the key players in this. And we're going to focus on slides 15 and 16, but Rich, let me give you a hypothetical. And the hypothetical is you're a potential strategic buyer, and we talked about strategic buyers, and you're a competitor. And you enter into discussions to buy company A, but not too long after that, that company basically tells you, well, I can't survive. It's a good thing. I can't survive long enough to get this to the end game. I'm going to file a bankruptcy, but I still want to sell to you. And I'm going to make you what's called a stalking horse. Tell me, are you happy or sad about that?
Well, I'm generally happy because one, the floor has been set for the bidding, so no one can outside of bankrupt it can't go on outside of bankruptcy that the debtor could take a lower price. You have the protections of the bankruptcy court, that you have all these stalking horse protections include a breakup fee and expense reimbursement. Generally, a breakup fee is usually, you know, 3 to 5% of the proposed purchase price, five being a little high, but generally 3%. And you have an expense reimbursement, which is your fees and costs to pay attorneys and financial advisors and bankers to do the diligence for the deal. Um, Again, that's part of playing in the sandbox of buying an asset in bankruptcy. The stalking horse protection, I generally view it as a good thing because your bid can't be shopped behind your back. It can be shopped, and if someone else, uses your bid to bid higher and ultimately get the assets, your time isn't lost. A lot of, and this brings in a point with the strategic buyers, you're generally not in it for your breakup fee and expense reimbursement. You're in it because you want the asset. They have a customer list you want, they have a social media account you want, they are in a region of the country or a region of the world that you want to be in that you can't get into, or their business is, been being run into the ground by bad management, and you see a great opportunity to fold it into your company. With the strategic buyer, the stalking horse, it sets the floor, but the issue is that you could get outbid, and that's just life in the sandbox of buying an asset in bankruptcy.
Well, staying on that for a minute, and I appreciate what you're saying in terms of it being a positive thing, but are there negative things when you want to advise your client as to when they come to the table to be a stalking horse?
Yeah, you could do all the work for someone else, for one of your other competitors, and they could come in and say, "Thank you. We have a bigger bank account. We can I'm just going to use numbers. Say the bid was $10 million. We can come in and offer 11 or 12, or we have an endless supply of money to always outbid you, and you don't have that cash to continue the bidding to get the asset." The You essentially are doing one of your other competitors in the industry, doing their homework for them.
Right. And as a stalking horse, if I represent the debtor, aren't we walking together lockstep to some degree? And why would I do that versus just throwing it up at an auction and say, here, higher and better, which is what the generally is done outside of bankruptcy?
Well, the higher and better, you're talking about, throwing it up without a stalking horse is called a naked auction, which that is beneficial to some debtors when the asset, when you don't, when the, ca- when the I don't want to say the asset is a melting ice cube, or it's not, gaining value the longer it's in bankruptcy. The melting ice cube concept could be the administrative costs of the bankruptcy are increasing. The longer you stay in the bankruptcy, the less likely you're going to get top dollar for the assets, even at a distressed price in bankruptcy. I had a case in the Southern District, an art house case called P8H, and the board quit, so the debtors council had no client to take direction from, and I was representing the committee. The judge went in front of the bankruptcy judge like the next day. He appointed a trustee, and one of the first things I suggested and got through, filing a motion on emergency notice, is to force the debtor to engage in an immediate sale process, even without a stalking horse. Because the thing with the stalking horse, you have to negotiate an asset purchase agreement. You have to do all the stalking horse purchaser wants to do their diligence. Sometimes you don't have time for that. And having a naked auction, sometimes, hey, whoever's got the most money show up at this auction.
So
And
let
a
me throw
rare
something
case
out.
though.
Let me throw something out to the group. Have you guys ever been involved in a sale where you felt that the stalking horse was just effectively a professional stalking horse, that they really had no interest in buying the assets, but were doing this for, the $1 million breakup fee?
Or to protect a pre-petition claim. I've had that situation where
Okay.
and they usually have a tell that their bid is not that much higher than the person who really wants it. It could be a nominal bid increment, depending on how the bid procedures are structured. But usually, if they're only in it for the fee, they will not be around long enough for the auction to go forward because there'll be it's almost like a game of chicken. They don't really want the asset, and if they get too aggressive, they're going to be stuck with something they don't want.
In my experience, I always tell buyers that, if you're going to be the stalking horse, it better be a pretty good deal, right?
Right.
You don't want to bid too high at your stalking horse offer. You want to reserve some money in the tank for the auction. Because look, if you end up putting forth a pretty good bid right in your stalking horse offer, you may have to own it, right? There may not be other bidders that come forward. So if I'm going to put the effort in and the work in to become the stalking horse, I generally want to leave a little bit of money on the table, in my pocket.
A
And
corollary to what James just said is this. Um, a stalking horse, the bankruptcy court isn't going to approve in almost any instance a stalking horse who says, oh, by the way, I have a due diligence out, right? By definition, there's no diligence out. And so the stalking horse, you asked your original question for this part of our webinar was, why might I not want to be the stalking horse? And that might be why. Um, competing bids can continue doing their diligence until the day of the auction, basically. But if I'm the stalking horse, I guess there may be an extraordinary case where diligence isn't out, but I haven't been part of any.
So,
Um,
John, staying with you on that, let's talk a little bit about non-disclosure agreements, or NDAs, as I like to refer to them, as part of the sale process and the data room.
hey, I never heard that before. You find that NDA? Sorry.
So, what are these typical in a bankruptcy forum? Are they typical in a non-bankruptcy forum? What's going on with this?
Yeah, they're an NDA. Or a confidentiality agreement, as some of us prefer to call them, a confi. They're hugely common in many corporate transactions. It doesn't need to be the purchase and sale of a company. It could be, in the context of a company looking at a new supplier or, a myriad circumstances. And the first rule of Fight Club, oh, no, the first rule of NDAs is, so the idea is I sign up an NDA with you. That means I'm going to give you access to some information that I want to stay confidential. I want it to stay private. Um, and what happens if you breach the NDA? Well, I can sue you. But nobody ever wants to have to go sue somebody. That's not fun. It's not necessarily easy. It's not necessarily, if some information gets on the street, um, proving that it was you may not be that disclosed it may not be easy. Maybe not. So a first principle, and they're no less common in the context of a bankruptcy, to be clear. It's a standard thing, and if you're dealing with I mean, it's like akin to malpractice usually, not to have to advise and for an NDA being in place. But um, the the first golden rule of NDAs is they're not magic potions, and somebody could break one. And so um the standard game plan is you don't sign the NDA and then disclose the secret formula to Coke. You stage, if you're the one providing the information, you reveal information in stages. So you don't give up your most important information, trade secrets, customer lists, pricing strategies. You don't give that up to all 17 parties that might ultimately be your stalking horse. You stage it so that you dance with the counterparties, you give them a level of information, and then as you get more serious and the deal becomes more likely, you open up more and more and more. All right, that's my opening bid to the
All
answer
right. Well,
question.
James, let me turn to you. So now you are representing the buyer. You know that this company is in bankruptcy. What are you going to demand in exchange for being the stalking horse?
I
And how
generally,
and how likely are you to get it?
yeah, I generally want two things. The first thing is, Rich spoke a little bit about it, which is you want some compensation if it turns out you don't get to be the buyer, somebody else tops you. Things like a breakup fee, which could be anywhere between 1% and 4%, a minimum overbid that somebody else has to bid to top you, expense reimbursement for legal fees and the like. Um, and the other thing that you want to do is you want to make it harder for another bidder to come in and outbid you. So you can set up some roadblocks, if you will. You can make it difficult for bidders to become deemed to be a qualified bidder by making certain financial hurdles or other types of hurdles in order to be deemed a qualified bidder. You could also require a minimum deposit, an upfront cash payment, maybe like a 10% or 20% deposit. You could, you also want to make sure that you include some of the things that you're going to want to see in the final sale order. Um, Things like the rights to be able to designate contracts for assumption or rejection and a timeline for that. Sometimes buyers don't want to undertake the work required to do that prior to the sale agreement being entered. So you may want to do that after the
Right.
sale has
Well,
closed.
James, as a follow-up for that question, okay, because I'm representing the debtor and you're representing the buyer, and I'm going out of business. So I'm only concerned about getting my principal his consulting agreement for $1 million a year. Once I've done that, I've done my job. I couldn't care less. You can get all of the covenants and everything else you want in the stalking horse so that you get it, so I get my $1 million. Who am I negotiating this with? Am I negotiating with me, or are you negotiating with the lender or a committee or the judge? How does that work?
Typically, it's negotiated between the debtor and the debtor's professionals, which would include the investment banker, if there is one, and debtor's counsel on the one side, and the buyer and its professionals on the other side. Now, oftentimes, other constituents will weigh in if there's a creditors committee appointed in the case. They're going to want to make sure that some of these terms are not overly rich. For example, the breakup fee, they're not going to want to see 10% breakup fees. That's probably not going to be approved by the judge anyway. Things along that nature. The secured lender, he's going to want to make sure that the sale price is enough to satisfy the secured creditor's claim. So all the other constituents in the case are ultimately going to be able to weigh in at some point. Prior to the stalking horse agreement being approved, it has to get submitted to the court, usually as part of the bidding procedures motion, and creditors will have an opportunity to object to any objectionable provisions, and so that's a way to kind of keep the agreement honest.
Okay. So John, let's turn to something else. Let's talk about, even though it's a sale through a plan. Is that still subject to 363? How does that work?
Well, No, it's not technically subject to 363. You asked earlier, why, I think you asked earlier, why someone, the benefits of buying through a plan, or acquiring through a plan.
Right.
And one benefit that I don't think anyone articulated was, to an extent, it can avoid, um, it can really sidestep competition, because the debtor has the exclusive right to propose a plan, for time limits and stuff, and to confirm a plan within time limits. And the rules surrounding the requirements to confirm a plan are different than the requirements to sell an asset under 363. And whereas, a sale under 363, in any commercial case, is going to involve an auction process subject to the higher and better bids. The confirmation requirements are simply different, and that's not one of them. Um, Now, I'm presuming we're not talking about an insider keeping equity on account of, an equity holder keeping equity on account of old equity. That puts us in a different conversation, and that does open us up to bidding. But if there's a third party, and this is something I've done a number of times over the years, there may be a third party with new money coming in. It's going to be the co-proponent of the plan, AKA, co-plan sponsor, and it's going to, acquire 100% of the business through a plan, and it's going to employ, one or more, former owners, executives, whoever, insiders, and those human beings may not be getting anything under the plan, but they're keeping their jobs, and there may be even a potential to earn sweat equity later. And that's can be a magnificent way to, sidestep the auction process that's inherent in 363.
Is there, just open to the group, is there a sort of a checklist to say, if I have X, B, A, B, and C, I want to do this through a plan, but if I don't have A, B, and C, I want to do this. How does one determine which way to go?
Well, John definitely covered I think probably the biggest one, right? The second one that you probably see a lot is when you're dealing with assets that are subject to transfer taxes, like real estate. Um, you can only have the sale be free and clear of stamp taxes and transfer taxes if the sale is accomplished under a plan. So that would be the other reason that I typically see.
Or another reason I see if you're issuing securities, you want to have certain securities be exempt from registration, under the.
Okay. Interesting. So let's turn for a minute just to cover some, on a high level, some elements of the, parts, nuts and bolts to the asset, the sale itself. And the first thing, James, I'll turn to you. What's an asset purchase agreement? Talk to me about it.
We talked a little bit about it. It's very similar to the stalking horse agreement, right? It's just basically the agreement between the buyer and the seller. If the stalking horse ends up being the winning bidder, then it will just be the stalking horse agreement. If some other competing bidder ends up being the winning bidder, then its agreement will control. And like I said earlier, this is subject to bankruptcy court approval. So to the extent that the agreement is inconsistent with what's in the sale order, typically speaking, the sale order will control. And so again, it's the byproduct of the entire process, which includes, the bidding procedures all the way up to when the judge hits the gavel, approving the sale.
Okay, and for the audience, now we're going to turn to the PowerPoint pages 22 to 24. John, why do I need bid procedures? What are they?
Before I answer that, I just wanted to mention, we also didn't talk about the concept of preserving NOLs in the context of a plan. Well, there's a bunch of stuff we didn't talk about. That's the one that comes to my mind.
Thank you, John.
You're welcome, Clifford. So, bidding procedures.
Yes, please.
through a combination of, the statute itself, bankruptcy code, and just sort of how things have developed over the years, the norms, the traditions, the market, quote unquote, the market, is that in a case, any commercial case involving a business of any size, um, there are usually two major steps or parts to the sale process. If you're selling something outside of the ordinary course of business, and thus need court approval under Bankruptcy Code 363, you again, you don't absolutely have to have an auction, but most of the time you do. And most of the time, in any case that, for example, one can read about in the Wall Street Journal, it will have had basically two sale motions. One's called it's called one of a couple things. It's the sale procedures motion, aka bid procedures motion, bid motion. They're all the same thing. And then there's either embedded, because it's a really long motion, you could call it and sale approval motion, and some law firms will do them as two pieces. There's a procedures motion and then an approval motion. But whether it's two separate pieces of paper or one piece of paper, the concept is that first you go to the court and say, "Hey, judge, we want to sell X. X might be substantially all the assets of the business. X might be a division. X might be, whatever, but we want to sell X. And here's how we want to go about doing it. Um, Richard's client is going to be the stalking horse. We have this APA, this asset purchase agreement that Richard's client has signed. We want to give Richard's client some bid protections, like we talked about earlier in this webinar. We want to have an auction on blank date. We're going to give it, we're going to put notice out to potential bidders, and here's what we're going to do. A little bit of a map of like, okay, we're going to put an ad in the New York Times. We're going to put an ad in Daily DAC. We're going to have an investment banker send teasers, whatever the plan to market the asset is, that's disclosed and laid out. And the concept is, judge, will you bless this process, so that you're approving you're not approving the ultimate sale today, but we're asking you in this first stage, bless the process that you say now, yeah, if you do those steps, I'm going to find that as a sufficiently commercially reasonable process, including the appointment of a stalking horse, or the the statement that there will be no stalking horse. It'll be a naked sale. Whatever you want to do, you preview to the judge and to all the parties in interest. And if you get an order, then you can proceed with comfort that as long as you do what you say you were going to do, at the end of the figurative day, whoever's the highest and best bidder, the judge will probably approve, but probably with an asterisk, because again, either there's a second motion, or it's embedded in that first motion that once the auction happens, then you go back to court and you say, "Hey, judge, remember that sale procedures you approved? Well, we did it. We're done. The successful bidder was at the auction was Bob," if that's the name of the company. And will you please bless Bob as the buyer? And so the court,
in getting there,
yeah.
John, Rich, turning to you really quickly, as I know we're running on time. What's this concept of credit bidding, and how does that play into this entirety? I'm not showing up with money?
Well, you're showing up with funny money. Essentially, for instance, for those of you who don't know what credit bidding is, it's usually when a pre-petition lender to a company, say they're owed $50 million and the debtor has only paid, $10 million of that principal debt. The lender, instead of having to put up fresh cash to bid at the auction, can do what they call credit bid. So my $50 million example minus the 10 that has already been paid during the life of the loan, the lender can bid another $40 million to acquire the assets. So it's essentially, they don't have to they don't have to put good money after bad.
Okay, so James, let me just turn to you because I know we're bumping up on time. I've done everything that I'm supposed to do. And now we're at the end of the sale, and there's a thing called a court order. Who's negotiating this court order? Briefly, if you can, and talk to me about why I need it, and does this end the process?
So yeah, so the sale order is typically negotiated between counsel for the buyer and counsel for the debtor with input from the creditors committee and the lenders council. And that's basically what you want the judge to sign at the end of the day. Once in order for him to sign it, he's got to find that the process was entered into in good faith, reasonable notice was provided to all the parties, the price is reasonable, the lender consents or some other exception to, lender consent is applicable. It's otherwise authorized under applicable law. So, those are the typical findings that a bankruptcy court judge has to make in order to approve the sale. If there's any objections to the sale, the judge is going to have to address those. So the sale order basically provides the buyer with what he needs in order to take good title to the assets and allows the debtor to get paid for the assets that are being sold. So it sort of adds a layer of finality. Now, oftentimes the order will also contain a provision that says it's immediately effective, even prior to any potential appeal processes.
Okay, so audience, this is an extremely interesting and complicated topic, and I appreciate my panelists and their guidance and expertise. Our hour is done. I'm getting notices that we have to conclude our webinar. Thank you for listening. We hope this was informative. Please check out Financial Poise's other webinars when you get a chance. Take care. It's been a lot of fun. And again, thank you all very much. And I look forward to speaking with you all about other interesting topics in the future. Take care.
Thank you.
Thanks.
Thank you.